My name's Dan Jackman, and I'm an Assistant Chief Reporter at the Planning and Environmental Appeals Division, and my colleague is Mrs. Lorna McCallum, who is a reporter. We have been jointly appointed by Scottish ministers to hold an inquiry into the Whitesands Project Flood Protection Scheme and prepare a report for the ministers' consideration. Before I go any further, just all the usual housekeeping points. We're not anticipating a fire alarm practice today, so if we hear the alarm, it's for real. If we do, I suggest that we stay calm and leave by the most appropriate exit. And the fire exit is over there, and we should gather in the car park, and members of staff will no doubt assist us. The loos are back out in the corridor on your left. Can I ask that all mobile phones are turned off, please? This session, as all our sessions, are being webcast, so you can watch yourself on TV tonight if you wish. You may be interested to know that at no time were there less than 50 people watching live all our webcasts. We're the second most popular inquiry this year, defeated only by the Royal High School in Edinburgh. We're always very keen to get feedback on our webcast, and apparently there is a link to click on, and Mr. Murray, our technician, will be eagerly awaiting any responses. This is the final session of our 4-week inquiry. It was agreed at the pre-examination meeting held in this room in August that this session would consider any modifications to the order or any planning conditions that would be attached to the deemed planning permission in the event that Scottish ministers were minded to confirm the order. We explained at that meeting that the fact that we wanted this session did not mean that we had made up our minds. Scottish ministers expect their reporters to address the question of modifications and conditions in their report in the event that they wish to confirm the order. That's standard practice, and in our report there will be a chapter relating to modifications and conditions. We completely understand that any discussion that we have today would be on a without prejudice basis. The hearing statements for this session were submitted before the main inquiry started, and for want of a better term, there were various agenda items under odds and sods. As the inquiry sessions took place, many of those matters, I think, were touched upon. So I'm not anticipating spending much time on those matters. Can I now just go around the tables and ask the parties to introduce themselves, please, starting with the Council.
Good morning again, sir, ma'am. I'm Craig Connell. I'm a Queen's Counsel. I'm representing the Council today. As many in the room know, I'm accompanied on my left by Ms. Emma Reid, who's one of my colleagues, Mr. Adrian Pringle, who many of you have met at various stages of this event, who's the project manager. I also have to his left Mr. Robert Duncan, who's a team leader, major developments from the same general department, and Mr. Stephen Herriott, who's head of infrastructure and transportation, in case their assistance is needed later on today. Thank you.
Yes, good morning. I'm Alistair Cargill, Operational Flood Risk Manager for SEPA. And on my left is David McNay, who's the Regulatory Manager for this area, and Lorna McLean, who's the Planning Manager in SEPA for the South West region. We also have Nicholas Gere, who's a flood risk specialist for the South West area, and also Fiona Naismith, who's a regulatory specialist as well.
Good morning, I'm Barry Dunn from Scottish Natural Heritage. I'm an operations manager here in Dumfries, covering responsibility for a number of areas, including some of our planning casework.
Morning, sir. I'm Steve Matthew, Managing Legal Counsel for Scottish Water, and I'm accompanied by Rob Fleming, who is our lead modelling manager for Scottish Water as well. Thank you.
Good morning, sir. My name is Peter Ferguson from Harper McLeod Solicitors. I represent Historic Environment Scotland, and with me on my left is James Bruin, who is Historic Environment Scotland's Deputy Head of Casework.
For Whitesands?
Yes, my name is John Dowson. I'm working with the Whitesands team, a small number of whom are here today. If you wouldn't mind, I ask them to maybe introduce themselves, if that's okay.
Peter Batchy, News Agents in the Whitesands. Thank you.
Willie Potts, Piccolo Coffee in the Whitesands.
Good morning, I'm Darren Miller, a local man here in my own name, but in association with Save Our Sands Group.
Rolf Coleman, local resident, Save Our Sands. Thank you.
My name is David Slater. I'm a local businessman, and I started the campaign, the SOS campaign. Sorry, is there a problem? All right, thank you very much.
Right.
Oh, we'll go again. Right, my name is David Slater. I'm a local businessman, and I started the SOS campaign, which thousands of people have signed.
John Greenwood, 252 Spares on the Whitesands.
Thank you. You will now be familiar with how a hearing session works. The hearing will be a structured discussion that we will lead based on the agenda that has been circulated. We will not allow any formal presentation of cases or cross-examination. We will lead the discussion by starting off each item of the agenda by directing a question at one of the parties. After the answer, we'll invite the other parties to comment in turn. That often kicks off a discussion and frequently generates other questions that we need to ask to clarify points. If you have any comments or questions as the discussion progresses, that's fine, but please make sure they come through me as the chair, and let the party talking finish the point that they are making, even if you strongly disagree with what's being said. In fact, particularly if you strongly disagree with what's being said. We shall be adopting a brisk pace. We will move on when we consider we have the information we need to write the report. Don't feel obliged to comment if all you're doing is repeating information that is already before us. We will be having a mid-morning break at an appropriate point in the agenda. And I may regret making this commitment, but I'm hopeful that we may be able to finish by dinner time. All that you tell us is evidence that we may need to include in our report, and you'll see us make notes. We may have to ask you to pause from time to time to make sure that we can catch up. Before I let anyone go home today and formally close the inquiry, we will discuss the matter of closing submissions so that I can get the case officer to confirm whatever we agree in writing as soon as we can next week. Before we move on to agenda item 2, are there any procedural matters that we need to discuss?
Excuse
Right.
me.
Oh.
Sorry, sir.
No.
I don't have an agenda. I wasn't sent an agenda for today. Is there any spares? I don't know when that was circulated, but I've been on my emails checking to see if there was one there, but thank you.
Okay, Mr. Dowson.
The procedural matter we wish to raise is about the closing submissions. So if you want to tackle that later, I'm happy, but I just want to intimate that now.
Okay, thank you. But let's discuss that after we've done the bulk of the agenda. Okay, then. On that basis, if we can turn to item 2, modifications to the submitted order. A, general principles. And we tickled this subject at the first hearing session. Our understanding is that Regulation 7.4 of Schedule 2 of the Act allows the Minister to confirm the order with modifications, and Regulation 7.5 sets out the process, which in summary is that the Minister should inform objectors of the modification, provide an opportunity to comment and consider those comments. Can I start with the Council? Is there any other legislative or policy guidance relating to how the submitted order can be modified?
Thank you, sir. And I'll give you a slightly longer answer than I hope I'll give you to any other question today, if you'll permit me just at this stage, in order to get it on the record. So far as can be ascertained, there is no guidance in case law on the word modifications in this statute, or indeed in this statute's predecessor act dealing with flood matters. So there's nothing to be gained there. Consideration has been given to analogous areas of endeavour, such as planning law, and I'll come to in a moment compulsory purchase. The position that the Council adopts is that, having considered these, the intention of the use of modifications was in the main to cater for relatively small changes, and that would the Council argue be in accordance with discussion, albeit in another context and subject to the usual caveat that reading across from one set of legislation to another brings its own risks. In the planning world, anything that is substantially different, or if you like the term materially different, is not permissible as a change to a proposal. And it has to be borne in mind at all times that it is modifications to the proposal that are under consideration, not a different proposal. In terms of materials, the only one that has come to hand, and again with the same warning about the dangers of reading across, is that the Scottish Government issued guidance to local authorities earlier this year on compulsory purchase, in which a section deals with modifications. Now, the document is, of course, available on the Scottish Government's website, but I have a hard copy for you, sir, and for Mr. Dowson. Just for the record, there is one section that deals with modifications, and if I just read it short for the moment, it's section 6.7. It says the power of modification is used sparingly and will not be used to rewrite CPOs extensively. And then there's a further provision in 6.8. Some minor mistakes or changes to circumstances can be corrected through the use of modifications, but not significant matters. And further on, there's no scope for ministers to add to or substitute statutory purposes or to add additional land to an order. Now, of course, that serves guidance in another area of endeavour, but it does respectfully seem to the Council to be consistent with their suggestion as to how matters might progress. I'm happy to provide the hard copies now, if that would assist.
Right, so you're formally asking for that to be submitted as a document?
Yes, sir. It seems to be it's a publicly available document. Anyone can find it on the Scottish Government website, and simply we brought hard copies for convenience.
Can I suggest that you let Mr. Dowson see that at the morning break, and we'll see whether that needs to be familiar, unless you know the answer now.
Well, I think I do. Sorry, it's late. It's not relevant. It relates to CPOs. This is a flood prevention scheme. It's the first flood prevention scheme in Scotland under the Act. There are no laid down rules and regulations that apply. Much as it's an interesting document, I have no objections to it being submitted, but I would have extreme objections to it being acted upon or used in any way.
Right. Well, can I suggest you have a look at it during the break, and then we can discuss that later on. Okay. SEPA, any thoughts or comments? Have you come across this situation before?
Yeah, I'll pass on to my colleague, sir, in a second. Just to make the point that within the Flood Risk Management Scotland Act, there's two routes to building flood protection works of any sort. One is Section 56, which is done with landowner agreement and funded by the council and or possibly private money as well contributing to that. The formal process which replaced the 1961 Flood Prevention Act is Section 60 of the Act, which has deemed planning permission and does have option for compulsory purchase.
It was just to raise the point that obviously we've got licensing requirements under the Controlled Activity Regulations and go through the due process of that. But if for any reason cannot license under the car authorisation, there may be requirements for modifications. That was just to raise that.
So your last point there was if the order itself wasn't altered, but as a second step, as we discussed at the first hearing session, there were difficulties in receiving regulatory approval under controlled activities, then that might itself require some tweaking.
Yes, that's correct. We'd be looking for modifications.
I'm going to look at the other agencies. Any thoughts or comments? Don't have to.
Only that any modifications to the current proposal would need reconsidered in their own right by us to determine whether there's other impacts which hadn't been already thought about. So we need to consider them in their own right and make a determination on those, what our view was.
Bushwater?
Yes, sir. Any modification to the scheme may result in some modification to our network in terms of the sewerage network and the water supply network. That simply means that we have to perhaps redesign what we do, but that wouldn't have any effect on the implementation of that because we rely on our own statutory powers for the purposes of laying pipes and building pumping stations, etc.
Talking about Scotland?
Two brief points, sir. If the scheme was modified, then if Historic Environment Scotland were consulted on the amended scheme, then they would consider and comment. And separately, a modification, depending on its nature, may impact on the needs for scheduled monument consent or other consents in which HES would have an interest.
Save Our Sands, any thoughts or comments on what you've just heard?
Yeah, yes, we would wish to make it absolutely clear that the proposal to modify is covered within the legislation, and it is covered within the decisions that the Minister can in fact make. I mean, there's only the three outcomes, and one of them is to confirm the scheme with modifications. So that's already there. I'm grateful to Mr Connell for pointing out that there is no guidance in case law in this statute, as he said, and therefore it is open to the Minister to consider a modification. We have proposed, as a stopgap, or as a backstop, which is the current word, a modification in the form that the bund design component solely is removed and replaced with a rising wall component. And we've heard specialist evidence on these two options, actually, throughout the time. We consider that to be only a modification to one design component. The majority of the flood prevention scheme is in fact wall. It's only 450 metres we're looking at. And we think that is well within the definition of sparingly, as the word was used, because it's only a modification to one part of the design. So we take the view that it is well within the Minister's remit or powers to consider that modification and hopefully, if necessary, approve it. But we make it clear that our first desire is to see the scheme rejected and not confirmed at all.
Yeah, we're going to come and look at your proposed modifications in a minute. That's a little bit later down the agenda. That's fine, don't worry. I'm just keen to understand the general principles at this stage, and then we'll look at your suggestions. I think we might have to go around the tables again. For the Council, just moving forward a little bit, if I understood what you were saying, really was that you can have a modification, but it's got to be we. Is there anything about the precision of a modification? Any guidance that there exists there?
I suspect, sir, like most things relating to this statute, there's not a neat handbook anywhere that gives us that convenient guidance. But the point, and it probably is sliding into the next topic to an extent, is that you have to say what the modification is. And that can be a challenging exercise if the proposed modification has not been assessed, studied, examined in detail, and brought to a detailed conclusion. Now, it's no doubt possible, perhaps, to have parameters, but it respectfully seems to the Council that if you can't specify in detail what the modification is, it's difficult to see that it can fall within that structure. How else can it be assessed? How else can others comment on it and respond to it? And that does give rise to issues. If you're saying, raise wall X by 6 inches, you can specify precisely where the wall is. You can specify the precise height amount. If you're going to do something more than that, then you need to say exactly what it is. And it respectfully seems to me, sir, that you can't just sort of make a general statement that it would be a good idea to do X or Y as a formal modification.
So your advice to us, not only should a modification be relatively minor, but it needs to be precisely expressed.
Yes, sir.
From the agencies, anything to add on that? looking round. Save Our Sands, do you want to come back on that?
Yes, please. There is no definition to say it has to be minor or wee or small, and therefore it could be major or large. So you know, the discretion is there for the Minister, and the Minister should be allowed to use that. I have some sympathies with what has been said, that in order to properly assess the detail of an amendment or modification, that further work may need to be done. And we would propose, perhaps later on, a further condition that a full and detailed and proper and fair option appraisal needs to be carried out between the council design scheme and any modification that may come forward, so that the Minister could be fully informed and the public could be fully informed. And we would be prepared to see that option appraisal ultimately could be put to perhaps a people's vote.
Okay, again, I think we'll need to discuss this a little bit more detail when we come to your suggested modifications. But just another point that occurred to us, and I'll start with the Council. Regulation 7.5 requires objectors to be notified. Is there any provision for other parties who were, say, perfectly happy with the original order but unhappy with the modification? How would they be captured, do you think?
Well, that doesn't, I don't think, appear to be directly dealt with in the notification provisions within the regulations, sir, but it illustrates to an extent perhaps the issue. If you're retaining the proposal but making some tweak, just to use that phrase, Mr. Dowson won't like it, but it's the one that has been used from time to time, then it may be that those who are content with the scheme, unless they are directly affected, perhaps it's their house that it's nearby or whatever, may be unconcerned. Whereas if you're going to do something notably different, substantially different, then it does almost amount to rewriting, and in a sense you're almost going back to square one, and fairness might dictate that that's not a feasible procedure. So it doesn't. There may be provision in. I'm reminded that ministers may dictate that other parties, other than those previously noted, ministers can determine that they should be notified. So that perhaps if I go back to my example, so if there was even a minor alteration, but it happened to be adjacent to some particular person's property or affected some particular person, even though they hadn't directly been involved as objecting or anything else, then ministers might say, well, you need to notify Mr. A or organisation B, and that would perhaps be the way in which that kind of alteration would be captured. But unfortunately, it's not obvious how a very significantly different scheme or proposal or alteration could readily be coped with within the existing statutory structure.
Would you go so far as to say that if the Minister was contemplating significant changes, the correct course of action would be actually decide not to confirm the order and instruct the Council to start again?
That would appear the logical conclusion, sir. If something notably different was to be proposed, I'm not even sure it would be open to the ministers to instruct the Council to do anything. The option would be to reject the order, and the matter would then be back where it started so many years ago.
Okay, I'll just quickly look at the agencies. Anything to add? No. Save Our Sands, any thoughts or comments on that?
Well, if that were to be the ultimate outcome of the Minister, then we would be supportive of that, because the important thing here is that if massive money is to be spent on a scheme for Dumfries for 100 years in the future, then we have to be absolutely sure that we've got the right scheme. And if there's any doubt in the Minister's mind that there is maybe a better option available, then the scheme should be stopped at that stage. We would have thought that ministers would have the power, if necessary, with a substantial modification to be considered, that the Minister would have the power to instruct that that modification could be subject of an advert, perhaps with a 28-day time for objectors under the Flood Risk Management 2009 Act. I thought there was a provision that the Minister could actually instruct a re-advertisement to invite objections, etc. And if our modification was accepted, we would be confident that there'd be a lot less objections.
Before we move on to look in detail at Save Our Sands suggested modifications, would Council want to comment on what Mr Dowson was saying there about the powers of the Minister?
So the regulations say what they say, but I suspect the difficulty that we're heading into is that, simply to take an example, the proposals in the current scheme have been subject of extensive environmental assessment and an EA, which covers a wide range of topics. If you're doing something radically different or substantially different, none of that has been assessed, and it would be challenging, at least, for the ministers to work out who to notify and about what at that stage, if that was the proposal.
Okay, I think we can progress this discussion by let's just now moving on to 2B, Save Our Sands suggested modifications. If I can start with you, Mr Dowson, in your hearing statement you make 12 suggestions. Not all of them are immediately obvious as modifications to the order. Some appeared to us to be general comments rather than actual modifications. So in the agenda we tried to extract what we thought were more obvious modifications to the order as opposed to other points. Have we picked you up correctly? Is that a fair? Has the agenda picked those points up?
Yes, I think you've been fair in that.
So, and can I just ask, are those modifications a package, or are you offering the Minister a pick and mix?
I'm having to think about that one. To some extent, they're a package because we would like to see them all, but we respect the Minister's discretion and ability to pick and mix if he so wishes. I mean, we are in, and this is where the without prejudice bit comes in, I think, because really we're not wanting to modify this at all. We're really wanting it not to be confirmed. So that's part of my difficulty. But what we would recommend is that the package of these modifications, amendments, conditions really would be the best thing in the public interest.
just so I'm clear, your first position is that you would advise the Minister to reject the order. Your second position would be that if he is going to do it, then you would recommend it be modified as we've set out in the agenda there. And your third position, if he wasn't persuaded by that, was that you would rely on the Minister's discretion for selected some of those bullet points. Is that fair?
Yes, up to a point, but we have a fourth position as well. And that fourth position is that you must keep in mind that these 12 points were written prior to this whole inquiry. And during the course of the inquiry, a number of issues have come up that have caused us concern. So today, or in our concluding statement submission, we would almost certainly wish to then propose further conditions that are not in these 12 points. So these 12 points are a bit historical, if I can put it that way.
We'll come on to conditions in a minute, but perhaps you could, just in relation to modifications to the order, what additional modifications are you thinking of?
Right. That's caught me a little bit. Just give me a second. There's a fundamental modification that we need to think about and talk about, and that is the case of Nunham. Now, I don't know where and when you want to consider that.
We have an item C,
right.
2C. So,
okay.
Was that the only area?
Can I just take a minute to just check? Yeah. You correct me if I'm wrong, but I'll raise a couple of issues. If you think this is inappropriate, please tell me. The first modification would be a climate change factor, which we believe is missing from the council design and has to be included. That would result in being a modification in the sense that a 3-metre high scheme with a climate change factor could not provide a 1 in 75-year protection level. It could only provide a 1 in 20-year protection level by our estimate. But that modification has to be built in our opinion, to the proposal. The other modification that we propose is that the DG Homes site, which is central to the council's current design, should be removed from the design proposal completely on strategic planning grounds, because that site is desperately needed for a multi-million-pound housing-related development, and the council have given in evidence and stated in evidence that they can quite adequately provide their scheme without the need for that site. So that's a modification that we're proposing, is that site is removed. I'll leave that as modifications because I think the rest are probably conditions.
Thank you. So the position of Save Our Sands is that apart from the 5 bullet points that we've put down in the agenda, in addition, you would be seeking a modification to, in effect, raise the bund to take into account climate change. Sorry, raise the wall. No?
I think you've misunderstood. If I can explain. Mr. Pert in his evidence talked about human scale. We do not believe that the bund wall or council design scheme can be raised for any reasons because it will take it beyond human scale. If you wish to put a climate change factor into a 3-metre high barrier, which cannot be raised for those reasons, then you must take the climate change off the 3 metres. Now, if you take Mr. Tim Jolly's evidence of at least a 20% climate change, perhaps as high as 44%, then you end up not with a 1 in 75-year protection, but something like a 1 in 20-year protection. So we do not think that the scheme should be raised beyond 3 metres, because that will take it beyond the human scale. But a climate change factor must be built into that scheme.
Right. So how would you, just taking that issue there, because I'm not sure I understand exactly what it is, how would you physically change the order that is before us? What wording changes are you seeking?
Well, the major wording change that we're seeking, and for the Minister's decision, is for him to recognise that this is not a 1 in 75-year protection scheme if you build in a climate change factor. If you build in a climate change factor of between 20 and 44%, according to Tim Jolly, hydrologist evidence, then you're effectively ending up with only a 2-metre permanent barrier, which equates to somewhere around a 1 in 20-year protection with climate change. Now, that is very significant, and a decision has to be made on that. We have been lectured for 4 weeks by the Council about how climate change is a very, very significant matter. We have been told that there will be more and more floods, that they'll be higher and higher. And the Minister has been asked to approve a scheme in which the Council has planned in a 0% factor for climate change. We think that is irresponsible and unacceptable.
No, I understand that that's your position and that's your critique of the technical evidence, and we heard all that. What today is about is how the order would actually be modified, and there's a difference between your criticisms. I understand you don't wish the thing to happen at all, but today's about how that be modified, and I'm struggling to see what you seem to be telling to me there is just that the Minister recognises it's not a 1 to 75-year protection.
Yes, because that has implications for other matters, and in particular I refer to the cost-benefit analysis. It has a significant impact on that.
Thank you. I'm going to go around to the other parties in a minute. Before we do that, I think I took you in one of the technical sessions to the actual order itself. That's the written document and the plans. Have you put any thoughts at all to how your bullet points and the 2 additional points you've just made, how they could, how you would actually change, for example, green 1 or Ms 1 in the order? Have you got that wording available, or are these just suggestions that you're inviting the Minister to think about?
Well, the suggestions that we are inviting the Minister to think about, we are accepting that our modifications, and I do accept some of the point made by the other side, need to have a detailed analysis, but that's why we're calling for a thorough option appraisal. We do not accept. The Minister needs to be told that our view is that no proper option appraisal has been done. And an option appraisal now needs to be done in which all of these matters will come out. The very detail that Mr Connell was calling for will come out from that. And that option appraisal has to involve organisations like HES, who have only been consulted about one option. They need to know what the other options are, because they're significant to the Devergilla Bridge.
Thank you. I do want today to be focused on modifications to the order. I don't want us to revisit issues that we've already discussed in evidence. But can I just start with the Council? Any thoughts or comments on the modifications suggested by Save Our Sands?
So, for the reasons that you've just illustrated, i.e. that many of these issues have been dealt with in evidence at various stages, I'll be brief because I don't intend to go back over all of these. The broad position adopted by the Council is that the whole scheme has been designed as a coherent whole. Everything ties together, one with the other, and that includes the steps consequent upon the scheme, including car parking and so on and so forth. And therefore it's not easy in the Council's submission to see how one can simply pick and mix bits from it. Looking at the list, and I think I can take this fairly shortly, replace bund with wall, and the fourth bullet point, maintain river views and parking, are probably close to each other if they're not identical to each other. Neither of these in our submission is a competent modification, not a desirable or appropriate modification for all the reasons that you've heard about in evidence. In respect of respecting Devergilla Bridge, well, of course, you know, sir, that the substantive position of the Council is that that's what they do. They are respecting Devergilla Bridge, and again, no change should be made to the arrangements proposed at Devergilla Bridge that have been discussed in such detail with the appropriate authorities. Incorporate green sands, well, I think that's probably focusing on largely on things like maintenance of river walls, which are dealt with under other statutory powers and wouldn't be an appropriate modification. We've heard other things about green sands, but that doesn't seem to be the focus here. Keep bus stance, well, you've heard evidence about what's proposed about bus stances. If it means leave things as they are at the moment, then that wouldn't be possible to fit within the overall coherent scheme which is before ministers. But, of course, the Council's position is that buses will remain accessing this area. So none of those on the agenda in our submission is either appropriate or, in many cases, even legally competent. The two suggested this morning, well, I don't really want to go back over ground that to a large extent we covered at the very outset at the first hearing session, but just so we're absolutely clear, the position of the Council is that they are doing what we are advised is the Scottish Government's preferred option. One does not build to climate change figures. One provides flexibility within the scheme to deal with climate change. On current figures, the scheme with each of its elements, including the demountable panels, meets the 1 in 75-year standard, and the proposal is to build the foundations in such a way as was explained in substantive evidence, particularly by Mr MacLeod, that if it is thought in due course that a change is needed to cope with increased requirements driven by climate change, that can be accommodated. How that would be accommodated, as Mr MacLeod pointed out, might depend on what was thought desirable at the time. But the idea that nothing has been done about climate change is just simply not correct. That foundations are to be designed, the structures in the ground, so that they can deal with that as and when required. That, insofar as I understand the climate change modification proposed, I don't think it's actually a modification at all. I think it's simply an argument. So far as the DG Home site is concerned, so again, you've had evidence on that. It would be inappropriate to modify the scheme by removing that site, which is part of the proposals that are before this inquiry. There's no reason to pluck it out. The position is as previously stated.
Okay, I'll just ask the agencies if the Minister was minded to look at the kind of modifications suggested by Save Our Sands. Any thoughts or comments from your particular perspective? If I could start with SEPA.
Not in particular. I think I would just like to reiterate partly what Mr Connell just said and what I said at the opening session, and just for clarity, I think for everyone who hasn't heard it before, I will say it again, is that climate change is not a legal requirement within the design of a formal flood protection scheme in Scotland at this moment in time. And as Mr Connell's alluded to, the government's preferred approach is what they call a managed adaptive approach, which is that no matter what the standard of protection of the original design of the scheme is, they want it to be built in such a way that it can be raised in future if required. And that, as Mr Connell said, accounts for any future climate change. So I can accept the arguments of wanting climate change to be included, but in terms of the Minister's considerations, there's not a legal requirement to include it. So just for the record, I think we need to be absolutely clear about that. That's all I wish to add.
Can I just push you a wee bit, some of the other suggested changes there? If the Minister agreed to Save Our Sands suggestion, would SEPA have a position on any of those?
I think with any modifications, without being involved, and any of us being involved from the SEPA side in the technical detailed inquiry sessions and hearing the details about these particular modifications, I think the more general point is that with any modifications, as far as I understand it, the 80-20% grant and aid funding would obviously still remain, but of course the contribution of the local authority, their 20%, may rise in actual capital costs, and you could also have particular time delays. So just to remind everyone to keep those things in mind. The other thing I would say is I'm aware that I think Save Our Sands are quite keen on this self-rising wall potential solution, but as far as I understand, such structures cannot be raised in future once they are set in place, so they are at an immediate disadvantage at the initial build and point of deployment compared to a managed adaptive scheme as has been proposed by the Council.
So we've heard evidence on the self-raising. S&H, any? No?
No, only just what I repeated, just repeating what I had earlier, that any of these suggested modifications would need reconsidered in their own right, to see if there was any additional impacts on natural heritage. So we would need to consider those and express a view on whether or not additional mitigation would be required in order to satisfy any natural heritage interest needs there, and we'd be happy to do so if the Minister decides that modifications would be granted.
Scottish Water, anything to add?
Nothing to add, sir.
Anything to add? Historic? No.
Yeah, the position is identical to Scottish natural heritage in respect of the historic environment.
Save Our Sands, do you want to come back on any of those comments?
The climate change, I mean, I understand or accept that it's not a legal requirement, but SEPA, I think, need to be clear that my understanding, and the understanding from the Council's hydrologist, Tim Jolly, was that there is a recommendation that at least a 20% factor should be built into a scheme, and that could rise as far as 44% in this locality. Now, I hear what is being said, that barriers can be raised in future and a managed adaptive approach can be considered. And I know that's what the Council scheme is proposing. But we're saying that is in contradiction or in conflict with the evidence given by Graham Pert, the designer, and it's also in conflict with the fact that the scheme is already 3 metres high. To raise the scheme by 20% in future would take it to 3.6 metres, and by 40-odd% would take it to 4.3 metres. It's way beyond the human scale. It's becoming ridiculous. And any minister who's going to approve that on the Whitesands would have a, well, I'm sorry, we just believe this scheme is going beyond credibility.
I fear we're in danger of going back on all the points that we've heard over the last 4 weeks. We noted a profound difference between the parties there, and we'll just have to consider that in due course. What I would say, Mr. Dowson, I would invite you to put yourself in the shoes of the Minister. If you're making suggestions about modifications, you might want to reflect in your closing submissions to be as helpful as possible as to what it is you're actually asking him or her to modify the order. I'm going to move on now. There were other suggestions that you made in your hearing statement. Including, for example, the review of public inquiry procedures, Mr. Swinney's comments, national standards of community engagement. My question to you is what is it you want to do? What is it you want us to do about those suggestions?
Take them one at a time, perhaps. Could you just remind me what they were?
Yes. Well, this is from your hearing statement. So I extracted the ones that seem to us to be about modifications, which we've just discussed. So I've got, for example, deemed permission is outline only, consult with community over level of protection and detail scheme, review of public inquiry procedures, wish of John Swinney not to fund something which doesn't have community support, effective and appropriate compensation scheme, council instructed to comply with the national standards of community engagement. I understand you've made these points to us in evidence on various occasions. In the context of today's discussion about modifications to the order, what is it that you're actually asking the Minister to do in relation to those suggestions? Is it just to note them, or what should we do about them?
Okay. Maybe I'm needing some clarification just on the detail. It's partly coming up under the Council's paragraph 2.2 that further detailed applications have to be made and dealt with. And this comes back to, is the deemed planning permission given by the Minister in outline in principle only, and therefore under the Planning Acts, is that then followed by a detailed planning application, as would be normal after an in principle or outline? And how is that then processed, advertised, and according to paragraph 2.2 of the Council submission, that would be determined by the EE&I Committee of the Council, which places the Council in a position of judge and jury on the detail of the application. And this is where we have to raise this thing about this is not a detailed planning application. It's not a planning application at all, but, you know.
That's something we're going to discuss later when we look at the planning conditions. What about the other ones?
There was a commitment made in this building by John Swinney that the Scottish Government would not fund any scheme that did not have community support. And we are clearly, hopefully, transferring a large number of the community's view that there is not community support for this scheme, and that should be brought to the attention of the Minister and, in fact, to John Swinney MSP and all MSPs. Now, you know, we are proposing and suggesting to the Ministers modifications that may get community support, and that's why we are proposing these modifications and asking the Minister to take them up, accepting that those modifications need further detailed analysis and inspection and all the other agencies to look at. We're calling for a full and detailed, further and proper option appraisal to be carried out, for the Minister to instruct that. And ultimately, we're suggesting that that should be the subject then of a re-advert of the scheme over a 28-day period, which would allow the community and the public to then make their views known about any such modifications. We are predicting, we're confident, that the modifications that we are proposing would be much more favourable with the community, and therefore the Minister and the Scottish Government would be much, much happier then about committing £20, £30 million to a scheme that had community support. And that's a commitment that was made, you know, in this building 4 years ago by John Swinney. The Scottish Government would not fund a scheme that does not have community support.
Yes. What I'm sensing from your answer there is that these additional points, what you're asking us to do is make sure in our report we convey those points to the Minister. We look forward to receiving your closing submissions to help us convey that correctly. I don't think we need to discuss any more on those.
Well, you mentioned compensation, which I think we're coming to later, and we do have points to raise on that if you want to leave that till later.
Yes, let's leave it to the point.
And the standards of community engagement, all we are asking there is that in all further proceedings between Dumfries and Galloway Council and the community, whether it's Save Our Sands or anyone else in this room or out and about, is that the Council is expected to comply fully and fairly with the national standards of community engagement, which is government policy, Scottish Government policy, and the Council's own policy.
Yeah, no, I understand that, and you've made that point clear to us on several occasions. The only reason I'm pushing a wee bit is I am keen to make sure I understand what it is you're asking us to do in terms of the actual order before us, but I think I'm clearer. So can we now move on to 2C, and if I start with the Council, in the general case, is a modification that extended the spatial extent of a published order competent?
If you take the matter generally, sir, I suppose it might be possible to envisage a situation in which a very minor change along the lines mentioned in the CPO circular, an adjustment of a line here or there or something of that kind, might be regarded as within the inherent powers to correct errors, for instance, or something of that kind. But in general terms, and if we try to relate this a little more to the reality, the inclusion of another area, to any substantial extent out with the scheme boundaries would not be a competent modification. So that's the general question, and then of course I don't know whether you want me to deal with Nunham directly.
No, I think your response doesn't surprise me in relation to what you said early on this morning, and I think I understand your position. Anything to add from the agencies? SEPA, any experience of this?
With respect to Nunham, I would suggest that the area that floods there, the route of the flooding, the actual pathway, may not be where certain parties think it might be coming from. The area of Nunham is located on the inside of a meander bend of the river there, so actually extending the scheme up and protecting this area of the river, you might get flooding from the north side because the water will back up at the A75 and flood from two directions. So
yes.
I don't know if it's actually
I don't want
modification at all.
Right, okay. I'm really focusing my question in terms of the SEPA's experience in the general case of changing the spatial extent of an order. What would be the implications of doing that in the general case? Forgetting about Nunham.
You're going to increase the costs. There's going to be ground survey work that has to be done. There's going to be localised impacts, remodelling, impacts to flood warning schemes potentially that might exist in an area, time delays.
Okay, thank you. Any of the other agencies want to add anything? Okay. Save Our Sands, any thoughts or comments about the general case of amending the spatial extent of the order?
It's been suggested it's not a competent modification, but it's got to be a fundamental reason for rejection. That the implication of the Whitesands scheme is that it will aggravate the flooding at Nunham, and that is why we are suggesting that either the scheme has to be extended to Nunham, or in our view, no scheme should be carried out on the Whitesands until a scheme is completed and installed at Nunham, because to do so on the Whitesands will be a breach of grant conditions, because we do not accept the evidence that the clearing of the sediment at Evergilla Bridge mitigates that. And the Nunham residents have a greater need. We're talking about residential properties. We visited it yesterday. We could see the kind of distress that's been caused to people, families, children, disabled people. Compare that with the Whitesands, where the businesses and people affected don't even want the scheme. Nunham is a greater case than the Whitesands, and that should be brought to the Minister's attention.
Thank you. Again, we're in danger of going over old ground. Today is focusing on modifications. Any other points on modifications? Are we done? Okay. Can we now move on to item 3, planning conditions to be attached to the deemed planning permission? We have a number of questions regarding the Council's suggested planning conditions, and we'll look at those in detail in a minute. But if I can just start off with Save Our Sands, and I think you touched upon this a little bit earlier. Is it appropriate that the Council discharges planning conditions for its own scheme, do you think?
Well, our view is that that is not appropriate. It puts the Council in the position of judge and jury. It also puts the Council in the position of effectively being the enforcer of those conditions. And it would place it in a conflict of interest, because the Council would effectively have to take enforcement action against themselves. This is not a procedure that we consider to be in the public interest. This is one of the procedural or mechanisms that we think is at fault in the whole system. We ultimately think there's a greater role for the community liaison group, which the Council themselves have proposed, and we will come to that later on. But we would ask the Minister to address this conflict and this nonsense, actually, where the council would actually have to take enforcement action against themselves. And we're not just talking about, can I say, the initial approval at the planning committee of EE&I. We're talking about 100 years of the lifetime of this project, where the conditions that are being laid down have to be enforced throughout that century. People, I'm afraid, locally are losing trust in this council from that point of view. We do not trust them to take enforcement action against themselves.
And have you any thoughts on an alternative mechanism if it's not the council?
Only very brief thoughts, and I think I'm not the best person to do that. We are aware that there is civil servants in Edinburgh, that people who I think you affectionately refer to as the client division, and we think that the client division may have a more, the civil service basically may have a more important role to play, and that would be that as and when the council is seeking either approvals or whatever, that should be referred to civil servants, and that perhaps there's some mechanism in government where the enforcement powers that would be needed would not be left to the council themselves, but might be taken either by the civil service or by the civil service in some ways in partnership with the community of all people. The community liaison group, we think, has got a major role to play. They would be the ones that would first identify any failures of conditions, and therefore they could interact hopefully with an independent agency, whether it be the civil service or whatever, to ensure that conditions are complied with.
Council, any thoughts or comments?
So this is dealt with in a number of ways, and it should be borne in mind that the council has statutory duties under the Act to deal with flood risk, and indeed would be obliged to maintain flood risk defences once constructed. It's not an uncommon situation to encounter, and to an extent it's catered for by the first of the proposed conditions, the appointment of a planning monitoring officer, in order to provide another independent view on the matter. So the council's submission is there's no need to do that. Planning authorities local authorities are developers from time to time, and that's catered for and dealt with because there are statutory boundaries within which everyone has to operate, and these may need to be enforced.
Okay. Another clear difference between you. Can I just address this question now to the agencies? As you know, the council have put up its suggested planning conditions, if the Minister was minded to confirm the order and grant deemed permission. Can I start with SEPA? Have you any comments or in terms of the scope of those conditions? Are you generally content?
Yes, SEPA would be generally content with the scope of the suggested conditions.
SNA?
Yes, we too would be content with the general conditions, yes.
Scottish Water? Historic and Scott?
Is this the general principle of conditions, or are we commenting on the individual conditions at this stage?
We will look at individual conditions, but I was trying to gather initial feelings as to whether Historic Environment Scotland were generally content with the scope and aim of the council's suggested conditions.
Yes, subject to the proviso that Historic Environment Scotland were not consulted and did not make detailed submissions on the scheme.
We'll look in detail at each one in turn, and if there are any points, then make yourself known. Save Our Sands. Any thoughts or comment?
Well, we'll look at the individual conditions, but just following the point made about, for instance, the planning monitoring officer and also ecological clerk of works. I'm just using this as an example, that we would favour that those employees with specific duties were not employed by the planning authority, but, for instance, as a suggestion, that these officers who have a very important job would be employed perhaps by the client division. So in other words, their line of management would be back to Edinburgh rather than to the local authority. That's just a very simple suggestion. We do not think it's appropriate that these officers would solely report to the council.
We'll get into look at each condition in due course. I was just trying to capture, just to help me chairing that. Generally, are you content with the council's suggested conditions? I know you're against the scheme in period. I know you want to have a different scheme if that's not possible, but I'm going to invite you to suspend your disbelief. And if the Minister was minded to approve the scheme and was minded to grant deemed condition, I appreciate there's a lot of caveats there which you don't accept, but I'm going to ask you anyway. Are you content generally with the scope and content of those conditions?
Well, the answer has to be no. We're not. We will deal with that as we come to each one, if you wish, in a bit more detail. And we would also suggest that perhaps there are further conditions that need to be included.
Great. That's helpful, Mr. Dawson. I now understand how I can run the next session. I think before we embark at looking at those conditions in detail, it would be an appropriate moment to take our first break, and then we can come back refreshed to roll our sleeves up and look in the detail of planning conditions. So if we can come back for 11:05. Right, in the Council's hearing statement, they put forward the conditions that they are recommending ministers attach to any direction giving deemed planning permission. We have a few questions about the Council's suggested conditions. I suggest we run through those. If other parties have any comments as we run through those, then fingers to the buzzers, but be quick, because I'll move on and assume everyone's happy unless you tell me otherwise. So can we kick off with the definitions? Any comments on the definitions the Council was proposing? I'm looking around. Okay. The first condition, planning monitoring officer. Can I ask the Council? Why is a monitoring officer necessary in terms of the conditions circular when it's a council's project, and presumably you'll have your own mechanisms in place to ensure the contractor does as they should?
Thank you, sir. Can I just say, by way of introduction to my answer, that I've been asked to remind you, sir and ma'am, that the proposal from the council as a whole is designed to build in two things. First of all, at various stages, the involvement of third-party agencies, and I have a couple of potential additions to that, which I'll come to when the appropriate conditions crop up, and also that the matter goes to a committee, so it's not simply an officer determination. So far as this condition is concerned, it's sometimes thought necessary in commercial development cases because it imposes a degree of what might describe as compulsory independence on the system. One can debate, no doubt, whether it's a good idea or necessary, and which side of that line it falls upon, but it was proposed because it was thought in part to deal with the kind of issues that we've heard raised here, that an independent party is concerned. Now, one can argue that it's not necessary in a very strict sense if everything else works well, but it could equally be regarded as a necessary insertion of an independent role.
Okay, any other parties on condition 1?
Excuse me. Just to raise the issue about who the employer could be or should be, and we believe that if such a post is created, that consideration should be given to employing that person out with the council, and we would suggest perhaps the client division as a possibility, or some kind of civil service employment, and that the role within the conditions, if I can refer to paragraph B and C in particular, where it requires the PMO to submit a monthly report to the planning authority and see the planning authority about any failures to comply. We believe that there's an enhanced role for the community liaison group, which will be coming to under number 4, and we believe that these reports should not just be made to the planning authority, but also to then the client division as the employer, but also to the community liaison group, so that the community is kept fully informed, and that there is a duty of the PMO to report directly to the community group.
Thank you. Council, any thoughts or comments on that?
Don't think it's necessary, sir, but I've noted the comment.
Condition 2, phasing. Any comments on condition 2?
It's the comment at the very bottom of the page that states that alternative car parking provision is in place prior to commencement of works. I'm referring back to Mr. Topping's evidence where he was asked that specific question, and I think the answer was the majority of the car parking provision. We would like to see a commitment that all of the replacement car parking is in place prior to the commencement of works. And we understood that that was originally the councillor's intention in putting that condition on themselves. So it's not just a question of a proportion of the car parking or the majority of it, and it's not just about it being part of one phase. What we're really saying is that is the first phase, or before anything, that car parking has to be put in place.
Council, any thoughts or comments?
Well, so we stick with the wording as proposed. The intention is that, as the wording says, that the alternative shall be in place in respect of permanent loss of car parking from any phase. That's designed to cope with the possibility, for instance, that a piece of car parking might be temporarily occupied during some form of work, and therefore there wouldn't be a need to provide a replacement for that, because it will return to car parking at the end. And in my submission, sir, it's a sensible idea to go with the phasing, that you make sure that you're providing for any permanent loss at each phase.
Okay, condition 3. Any comments on that? Mr. Dowson, I see you're reaching for the buzzer.
It's about it's again about who's involved in agreeing to the commencement of development of any phase, and we would wish to see a role for the community liaison group in that. In other words, before anything this is to do with commencement of development any phase, that there should be a role for the community liaison group in that. There's specific mention there at the bottom saying, or in the middle saying, that the phase has to be submitted and approved in writing by the council in consultation with Historic and Environment Scotland. We would like that to also include and the community liaison group.
Thank you. Any other points on condition 3? Council, any thoughts or comments on Save Our Sam's suggestion?
It's not a necessary part of the role proposed for the community liaison group, which we're about to come to. So this is the formal approval of plans after consultation with the appropriate statutory bodies.
Okay. Condition 4. I've seen this kind of solution on many occasions. It's commonly used. But why would you need a condition? Could not the council organise a community liaison group and just do it? Why does it need a condition for there to be a community liaison group?
It was thought, sir, in light of the nature of the scheme and the issues have arisen in the scheme, that it was, to use that word, necessary to include a condition specifically requiring the appointment, opposed to leaving it simply open to other arrangements. And it also enables the function of that group to be considered and defined at the time that it's put in place, rather than that also left potentially for the search for the elusive consensus, which might not be necessarily very easy to achieve if it was just left without any guidance.
Any comments on condition 4?
Yeah, well, we welcome this condition, and we think it's important that it is a condition, because the fear is if it is not a condition, that it may not happen, and it may not happen to our satisfaction. But we are looking for an enhanced role for that community liaison group, and we're looking for a role that doesn't just relate to the construction period. So there is an important role for this group during the construction period, but also for the 100 years in the future. So we see this as a permanent group, and we see it as a group that has to have partnership status with the council. It has to be involved in decision making, and this is where the national standards of community engagement principles that we've asked about become very, very important. This is where adherence to those standards is critical. The condition talks about the community liaison group being a vehicle for the community to be kept informed. Now, we do not think that's adequate. This is not a group that is simply being kept informed. This is a group that must participate fully in the decision-making process about the phasing during the commencement of works, during the whole construction period, and then be involved in the ensurance of compliance of conditions thereafter throughout the lifetime of the scheme. So that group will need to be resourced and will need to be given the status of a meaningful partner in the decision-making process throughout the lifetime of this scheme. So we don't see this just as being a bystander, a sort of innocent bystander role for this group. We think that group would have to be made up, we would hope, certainly of representatives from Saver Sands, but there's wider objectors, wider community interests as well. So we do welcome this. We think it's an important condition, probably the most important condition, almost, but it needs to be given proper status.
Those comments are helpful. I don't suppose you have a form of words in mind, do you?
Not precisely at this moment, but we would certainly include something more detailed, if you wished, in our concluding statement, if that would help.
I think it would be helpful, yes. We've obviously noticed your objectives and direction of travel, but it's always helpful, rather than us trying to divine, for parties to actually tell us what it is how they want a condition to be written differently. So yes, what other parties in your position have done is included an appendix in their closing submission. Thank you. Council, any thoughts or comments on Save Our Sand suggestion?
Well, they probably fall into two parts. One is the suggestion that this should be a permanent body. The Council don't accept that proposition. This is a group that is focused on a period of time which has been identified by objectors of particular concern, during which construction and the phasing of construction and the practical arrangements for access and so on have been matters of considerable concern during the process, and the intention of the group therefore is that the functioning of the group should be through during that process. Once the flood protection scheme is built, then statutory duties to maintain it and so on and so forth come into play, and the Council's position is that the normal democratic processes would then operate in terms of the future conduct and maintenance of that scheme. So far as the role of the group is concerned, there's no hiding the fact that the condition is drafted as an arrangement for information. Now, that's not simply information to the group, but information from the group, so that the issues, the practical issues, can be taken into account and brought through a compulsory forum to the attention of the Council. But there will remain technical decisions to be made, particularly during construction, which have to be made, as I think we heard from one witness, by those technically qualified to make them, not by some form of committee process. Contractors may need to do X or Y at the appropriate technical time, and that can't be the subject of some further process. So the proposal that the group has some form of role in actual decision making other than ensuring that the relevant information is available is not included within what is proposed here.
Okay, thank you. Anything else on condition 4? Right, condition 5, landscaping. In relation, well, can I ask the Council, the third part of that condition, again, when it's a council scheme, why is that third part necessary? Surely you would ensure that your contractor would look after those things, the planning powers.
Simply design so as I think is not uncommon in other circumstances, to ensure that that there's a detail of specification. But you're right, so it may be that the council would not need to have it, but it was thought appropriate here, given in particular the amount of concern about the maintenance issues, to write something in that makes it absolutely plain what the position is in that section. It just makes it more precise, perhaps.
Any other comments on condition 5? Mr. Dowson?
Excuse me, just to welcome condition 3, I think it should remain as a condition. If you've been following the local press lately, the council has been involved in the chopping down of a number of trees, which have caused aggravation within the community, and there has been problems in getting assurances that these trees will be replaced in a timeous way, and with appropriate replacements. This is actually, at this very moment in time, a very big issue. So we would welcome that condition remaining.
Thank you. Condition 6. Any comments on condition 6? Right, so I'll move on. Condition 7. If I could ask the council, what's the difference between a construction method statement, construction environmental management plan, and construction traffic management plan? Is there not scope for condition 7 to be amalgamated with some of the other ones?
Yes. One could draw them together. So I think it's simply that different topics have been separated out, given potentially different roles of different agencies in the production of the different sections, but it's essentially designed to ensure that the contractor has got all this material down in writing on an obligatory basis. So it's possible one could have had a section headed, construction plans, and dealt with a number of headings under the same section.
That's essentially a style choice. Yeah. Any other points on condition 7? Oh. SEPA.
Yeah, it was just in regard to the construction environment management plan. Welcome the wording in that, and it will include SEPA and other agencies in dealing with that. Just wanted to highlight the issue that if the overall construction site is greater than 4 hectares, which I'm not sure what the situation is at the moment, but it will require a licence from SEPA with regards to construction site drainage. But I'm not entirely sure whether it's greater than 4 hectares or not.
Okay, SNH.
Sorry, just to go back and touch on 6 and 7, ecological management plan, ecological clerk of works, and point 10 of a European protected species. It may be that those could be grouped as one, given they're all interrelated. The environmental management plan could set out a requirement to say, well, as part of that we will have an ecological clerk of works overseeing that, and we will address European protected species issues as required.
But that's again a style choice rather than anything deficient in the wording. Yes, okay. So we'll have to see whether the minister is a combiner or a separator. Anything else on 7? Okay. Condition 8. Clerk of Works. Anything on that, Mr. Dowson?
Similar to the planning monitor officer, we would like to see this post being independent of the council, being recruited independent of the council, perhaps accountable to civil service, Edinburgh, whatever. And also under paragraph C and E, it talks about this officer submitting a monthly report to the council, etc. Now, just as we said with the previous post, we would like to see the duty to report to a wider body of people than just the council, and that would again include, for instance, the community liaison group. And we think it's important that there's a good relationship between the community liaison group and this post.
Okay. Anyone else on 8? Council, any thoughts or comments on Save Our Sands suggestions there?
Same position as before, sir. As you'll be familiar, that those who take these appointments function in accordance with professional standards. No doubt they try to have good relations with everyone, but the point is they're meant to be independent and apply an independent mind, and that's what lies behind this. And the Council's submission, what's proposed, is sufficient.
Could I comment on that? I mean, I'm finding that a little bit unacceptable. That the suggestion that community groups can't take a professional view on things. This is not, that's not an acceptable comment.
Right, well, I hear the differences. What we're looking at is suggested planning conditions. I've taken down a note of Save Our Sands position, and I've noted the council's. I don't think we can move that any further. Anything on condition 9? Looking around. SEPA?
Just to request that previous comments that I'd made earlier are taken into account with condition 9 as well, regarding the scale of the site.
Anything on condition 9? Mr. Dowson.
Simply to ask for the inclusion of the community liaison group in there as well, please.
Anything else on condition 9? Okay, I'm moving on to condition 10. Any points on condition 10? Looking round?
Yes. Under number 1 there, traffic management plan has to be submitted to and approved by the council. We accept that, but we would like the words of in consultation with the community liaison group.
Anyone else on condition 10? Any council? Any thought? Oh, yes, SEPA.
It was just with regards to N2E, where it says about wheel wash measures to ensure water and debris are prevented from discharging site onto the public road. Again, I think there should be recognition made of ensuring that there's no discharges to the water environment as well.
Would your concerns be addressed if we added a phrase that the approval of that plan be subject to consultation with SEPA?
That would be fine, yes.
Council, any thoughts or comments on those suggestions?
I think, sir, it's recognised that there are constraints on operation of construction sites which are designed to prevent discharge into water resources, usually rivers or the like. I think the intention has been to build these in somewhere, but if there's to be a discussion with SEPA, then there's no objection to that being added in.
Okay. Anything else on 10? We done? Condition 11. Anything on condition 11? Looking round. Okay. Condition 12. Archaeology.
So, just on 12, after discussion, a brief discussion with HES this morning, the proposal is that after consultation with HES be written into the provisions of condition 12 and indeed 13, but condition 12 is what we're dealing with at the moment.
Okay, thank you. Anyone else on condition 12? Mr. Dowson.
Yeah, could I refer to Darren Miller perhaps for a comment on this?
Okay, I can put forward Mr. Dowson's notes that no development shall take place within the site until a scheme of archaeological investigation has been submitted to and approved in writing by the Council. Also that access shall be afforded at all reasonable times to any archaeologist nominated by the Council to allow them to observe work in progress. I could also add, for my own part, the wish that the Council should take a wider view of archaeology and heritage than it has done hitherto, taking in such aspects as the Whitesands public toilet, which is a former waiting room and an historical building, 90 years old. Also the Sandy Entry, or opening, which is an historic site, and the coveted watercourses.
Right. Have you put any thoughts to how you would actually change the wording of that condition 12?
No, I haven't.
Right. I just wondered, actually, strictly speaking, should there not be an implementation clause on that condition? Scheme approved and then to be implemented.
There's no issue with that.
Okay. Anything else on condition 12? Right. Condition 13. Any points on condition 13?
Same alteration proposed, sir, after consultation with HES.
SEPA?
Yes, with regards to the accumulation of sediment there, although we will probably put a condition in any controlled activity licence that was issued, it may be worthwhile adding to this condition to say that this monitoring will lead to the justification for sediment management in the future.
Okay. Anyone else on Mr. Dow?
We're not happy with this condition at all, any aspect of it. If you read it, we don't really know what the purpose of it is. It's not clear. We obviously do not accept that any form of sediment management under the Devergilla Bridge is going to mitigate the Nunham situation. We've got to start from that principle. But if such a condition is going to be put in, then it needs to be much more clearly worded than this. For instance, it's got to have to state clearly what the baseline is that sediment management might be taken from. And that baseline would have to be agreed with the residents of Nunham. who have a very strong opinion on this, there would also have to be a clear statement as to just how any further sediment build-up would actually be measured. There'd have to be a clear definition then as to what trigger points would be agreed for further sediment management over the 100-year life of the project. If you read this actual condition, it only talks about that it will be regularly monitored for the lifetime of the scheme. And in terms of any suggested removal, that would be submitted to and approved in writing by the council. Again, the council is in total control of this situation. So if this condition is to remain, then we need to see involvement of the Nunham residents, perhaps through the CLG again. But this, we would call for a complete rewording of this condition to be much more specific, much more clear, to refer to baselines, measurements, triggering points. My own view is that you would have to consider an annual sediment removal, because the minute you remove it, it will start to build up again. Now, the way to avoid this condition is quite simple, is to accept that Nunham should have protection prior to the Whitesands scheme going ahead. It's as simple as that.
And again, are you going to give us some suggested wording for an alternative condition?
Very reluctantly, I have to say, yes. I can't give you that just now, but if you would accept that in a closing submission, but absolutely without prejudice, that has got to be, because our stance clearly is Nunham is a far more deserving case. The way to avoid this condition is to tackle Nunham first.
No, it's understood that this you won't be undermining your case by suggesting wording to a condition. Council, any thoughts or comments on what you've just heard?
I don't think so, sir. The substantive evidence about this matter has already been given, and I'm not going to go back there. I realise Whitesands doesn't accept that evidence, but we will be asking the ministers to accept it so that once the sediment is removed, there will be no flooding elsewhere, including Nunham, caused by the scheme. And it's intended to be a relatively simple monitoring exercise once the sediment is removed. Easy to market and monitor it, so it's not anticipated to be a major exercise. No doubt at some point, but when that point is a matter for technical advice. But perhaps many years in the future, something else may need to be done. But that's a matter on which we've already heard evidence.
Okay, are we done on the council's suggested conditions? Mr. Ferguson.
Two brief points. Firstly, as with condition 12, I think there should be an implementation limb to the condition. And secondly, for information purposes, both the initial proposals for removal of sediment and potentially further removal of sediment would potentially require a separate scheduled monuments consent.
Okay, any further points on the council's suggested conditions? Are we done?
Moving to other suggested conditions.
Yes.
Shall it?
Yeah. Let's eat our elephant by chopping up into lots of little pieces. So we've looked at the council's suggested conditions, and the next item on the agenda is any other suggested conditions. And you kindly alerted us to the fact that you had some alternatives, so that's an appropriate point to ask you what additions you had in mind. But before you go, just to give us an idea, how many new ones?
No, there relatively few. In fact, 3 of them are covered by other matters, which is to do with the fair, land ownership and compensation. So I'll leave them till there, shall I? But there's just one really that I wanted to just raise with you at this point, and that is to relate back to the cost-benefit analysis, that we believe that the Minister should, as part of his decision, publish a revised cost-benefit analysis calculation at the time of his or her decision. You will know, and we have already written to say that we do not accept even the revised cost-benefit analysis that has been put in. We believe that this scheme fails on the cost-benefit analysis calculation. We're calling for it to be independently audited. We're pointing to the fact that Councillor Andrew Wood, who is the Vice Chairman of the EE&I Committee and very, very involved in the approval of this scheme, has recently indicated in the press that the costs of this scheme will be around £35 million. Now that is different significantly from Dr. Chatterton's figure of £25 million. We need to get these
sorry,
figures.
Mr. Dawson, I'm going to stop you there because this hearing session is about planning conditions on the deemed consent, I understand your position in relation to this matter. I was there when you gave evidence and cross-examined, there's no problem at all with you expressing Save Our Sands' position on these in due course in your closing submissions, and we'll convey that to the Minister. But just for today's purposes, we are looking at other conditions over and above the ones suggested by the Council. So what other planning conditions are you suggesting?
Well, I think they will be covered in Section 4 of your agenda.
Right. Thank you. Any other suggested conditions? Looking round. Okay. So can we now then move on to item 4? And let's start with 4A. Can I start with Mr. Miller? Since you wrote your hearing statement, we've had the benefit of hearing technical evidence from Mr. Sharp, and we've also discussed some of these issues at the initial hearing session. Are there any further points you'd like to add over and above your submitted hearing statement?
I have a question for Scottish Water, if that's allowable, with regard to the culverted watercourses and indeed to all the drainage network across Whitesands. And this expands on the question I asked in the first hearing session. Now, we know roughly the courses of the streams and how they've been incorporated into the drainage network. However, there is no information on the condition of these services because there hasn't been a proper drainage assessment since 1983, the one by Batty, Shaw and Morton. In their report, they're very critical about the then current network, which they describe as poor to fair, including 19th century brick culverts, a lot of siltation and low capacities. They recommended repairs would cost about 4.2 million, or about 6 million by modern in modern money. So my question is, what are their thoughts on the current condition of the network, which isn't covered in the recent report? The repairs that are needed, irrespective of the current scheme, and the extent and likely costs of the work would require if the scheme were to go ahead.
Right. Thank you for that. We need to be mindful that this inquiry is into the order that is before us. We're not looking at the Scottish Water's assets generally. Can I just ask Scottish Water, is there a quick answer to that question?
Not really. The coveted watercourses might not belong to Scottish Water. So all I do know is that some of them have been included in the model. I couldn't state the condition of the structural condition of the culverts at this point.
Okay, anything else on the Colvard watercourse? I'll let you have one final concluding remark on this, Mr. Miller, and I think we need to
Yes,
move on.
indeed, I understand. I should just explain. I asked this question of Scottish Water because it's the only opportunity I have to do so in the inquiry, and it's an important point.
Thank you. Item B, fair and charter rights. Again, this has been touched upon in the inquiry sessions. Anything that you feel you need to add, Mr. Dowson?
Yes, I think so. We think this is a wholly unresolved issue that needs to be resolved, needs to be brought to the Minister's attention. In terms of the order or procedure, any alternative site for the fair, we believe, has to be established through a proper process, which would involve potentially, perhaps, some kind of planning permission or neighbour notification with regard to alternative sites for the fair. Now, that would include temporary sites during the construction period, but also any final location of the fair. We have not accepted the point that there are no charter rights. There are clearly charter rights in the Dumfries Charter for a fair to be held 2 times a year. That we believe the Council has a responsibility and an obligation to ensure that that can happen. And if we understand that the implication of the Council's scheme is that the fair basically will not be able to be relocated in its current position, not the full fair. So until there's an agreement with the Cadona family or whoever, and a proper site's identified, what we are seeking here is a proper neighbour notification of all those properties that will be in close proximity of that site, because there will be considerable noise and traffic set up, all sorts of disruption going on, and we don't think that the fair should be relocated in near residential properties without those residential properties being properly notified.
I fear we're going to go over old ground, but thank you for that. Council, any thoughts or comments on that matter before we move on?
Just to add, sir, which you already know, that the temporary uses don't require planning permission, so whatever route is to be adopted, it won't be that one.
Okay. C, land ownerships. Again, we've touched on this in the inquiry sessions. Save Our Sounds, any additional points you want to make?
Well, basically, there's 2 points that we think are also unresolved, and that is the ownership of the Devergilla Bridge, the ownership of the Whitesands itself. Our understanding is that any approval from HES, for instance, first of all requires a notification on the owner. And if the owner cannot be defined, then there's no owner to notify. I'm aware of a precedent, I think, in this regard. The Scottish Parliament discussed the Black Coolins in Skye in the year 2000, I think it was May the 11th, where there was a significant problem over identifying the owner of the mountains. And that proved to be insurmountable in that case. I believe it's insurmountable in this case. We have put an FOI to the Council about this very point, and the Council cannot prove ownership of either the Devergilla Bridge or the Whitesands. So until such time as that ownership is resolved, we don't see how notifications can be properly served. So we're raising that point, and we're asking the Minister to be fully satisfied about who actually owns these assets.
And would you go so far as to say that the lack of clarity of the ownership, in your view, is fatal to the Minister approving the order in its own right?
Yes, we would go that far, and I haven't got the detailed evidence of this, but I believe there is precedent for this. I'm referring to the Coolins case in Skye. It needs someone better than me to fully research that, but it seemed to me that I believe that was potentially a fatal flaw in that particular thing, that the ownership could not be proven. So I have asked the Council for proof that they own these two assets, and they have been unable to provide it so far.
Thank you. Council, any thoughts or comments on that?
Not a matter that ministers need trouble themselves with, sir. The Council is satisfied it owns the Whitesands. Title deeds were somewhat limited at the time of Devergilla Bridge originally being founded, but there's no reason to think there's an issue there either.
Okay, there's a clear difference there, which we've noted. D, compensation scheme. Again, we discussed this at the town centre inquiry sessions. The Act says what the Act says in relation to compensation. Save our sands. Anything you feel you need to add to what we've already heard?
Yes, if I could. With regard to compensation schemes, the commercial properties, the Council has identified 91 commercial properties potentially affected. These 91 commercial properties have not had any information about this. We need early information out about to all of these 91 commercial properties and perhaps beyond, because this scheme may affect beyond the 91 identified properties. Due to the precedent set in 2015 by the Scottish Government, who actually paid out compensation on the Whitesands to Whitesands traders and residential properties, we are expecting the Scottish Government to honour a similar compensation scheme. So we are certainly looking for a compensation scheme to be made available to at least the 91 commercial properties and the 45 residential properties. And we also understand a precedent was set at that time where residents of Nunham, some residents of Nunham, also received compensation payments, and we make the case now that the residents of Nunham should be included. Well, I think any resident in Dumfries and Galloway should be included in being eligible for a compensation scheme if flooding is caused. But focusing in solely on this scheme, what we're saying is that we understand the discussions up till now have been about compensating commercial properties. At least 91 have been identified, but we think that should be extended to residential properties, as was done in 2015 by the Scottish Government. So there is a precedent for this.
Was that previous compensation, that we need to be clear, any compensation would be as set out in the Flooding Act. And there's various forms of compensation in various circumstances. In terms of our narrow remit, in terms of our advice to ministers, what is it you want ministers to actually do over and above what the Act says?
Well, first of all, to recognise the narrowness of the current provisions, and if those provisions are only available for commercial properties based on things like 3 years trading accounts, and if they need 3 years trading accounts, well, they better get their accounts together now, they better get the information now. But compensation was paid out to residential properties. So we would ask the Minister to recognise that precedent and put in place a mechanism for the future so that residential properties in the Whitesands would also be able to acquire compensation, that to be extended to Nuneham. And if the Minister does that, he'll be doing a good thing, because he'll be creating a precedent for the whole of Scotland, which would be wonderful.
Okay, thank you. Council, any thoughts or comments?
I suspect we're dealing with different things, so that the compensation provisions in the Act deal with the consequences of the flood scheme. It may be that in certain circumstances parties have received perhaps ex gratia compensation from Scottish Government when they've been the victims of flooding, but that's not a matter for you, and it's not a matter for the ministers in this scheme.
Okay, that's all the other matters. Is there anything else that we need to discuss today? Are we done? Before I talk about the procedural points.
You give me just a minute to check, please. Just a second. I think there is something else. Let me just check. Could I raise two other matters that we consider might be relevant? You can rule on them, sir, if you wish.
Right, you better tell me what they are.
We're calling for the Council to publish and agree a full ongoing short and long-term maintenance schedule for the completed scheme, particularly in relation to such things as glass cleaning, litter picking, plant and grass maintenance, etc. And this has been brought about by comments made by one of the senior engineers and evidence that he stated that the integrity of the scheme was more important than the maintenance. So we would ask the Minister to ensure that as part of the conditions or as a relevant matter, that a full maintenance schedule for the completed scheme is published and costed. That would be the first point.
What you're saying is there should be an additional planning condition requiring that. Before you go on to your final point, can I just ask the Council any thoughts or comments on that?
So as I understand it, if flood schemes are put in place, the Council is obliged to maintain them, and therefore any such condition would be duplicating that statutory obligation. If we're talking about what one might describe as the sort of parks-related issues about trees and plants and so on, no such condition would meet the test of necessity.
Okay, your final point?
We raised about the impact on the town centre and the fact that no retail impact study had been done. We are asking the Council, or as a condition, that in terms of the loss of car parkings, particularly on the Whitesands, that a further retail impact study should be carried out, not just retail but business impact study in terms of the impact on the High Street. We are aware that the Council has a report within its, has done a recent report using Ironside Farrer consultants from Edinburgh on this very subject. We have submitted a Freedom of Information request to get that report, and it's been refused on the grounds that the study is not complete. We are asking the Council to complete that study and publish the outcome of that report, and if necessary carry out a further business impact study in terms of our High Street.
Unless the document's before us, then it's not anything that we're involved in. So just to summarise, you're asking for a further planning condition which would require the Council to carry out what you called a business impact assessment. Is that it? Yes, thank you. Any thoughts or comments on that suggestion?
That would be neither a necessary nor appropriate condition at this stage of matters. So I don't have information about the report that Mr. Dowson's mentioned, but I gather it's nothing to do with the scheme.
Okay, I think that's us done. Oh, SEPA, yes?
Yeah, sorry, sir. Just to, for the purposes of informing the Minister, we've talked a lot about modifications or without modifications to the scheme. There's also the number one preference, I think, as you outlined for Save Our Sands, that the scheme would be refused. And I think there's important procedural matters in terms of the legislation. So if the scheme was refused, the local flood risk management plan that the Council has a duty to produce would have to be updated to reflect the fact that the scheme would not be progressing. The level of flood risk for Dumfries, as shown on the National Flood Risk Assessment that SEPA has a duty to produce, will of course not change if the scheme wasn't going to progress. There would be no requirement for significant alterations to the flood warning system, the statutory flood warning system that we currently in SEPA run for the River Nith. The next flood risk management strategy for this area would only include the proposition of a new or a different scheme, following again the same process of review of data sets available at the time, and of course discussions and negotiations with the Council. And I think maybe most importantly, the local authority may have to wait until the next flood risk management planning cycle to promote another scheme, so that would be 2022 onwards. I know there's a 10-year funding package in place to cover flood protection schemes by the Scottish Government as existing. I think beyond that, no one really knows what the funding arrangements may be in future.
Thank you for that. I'm not keen to widen discussion. I'll let Save Our Sands have one last word, and then I'm going to move on to concluding remarks.
Yeah, I'm actually very grateful to SEPA for that intervention and suggest that I'm grateful to them for outlining the way forward for this Council. They've just summed it up. A delay of some 4 or 5 years might be the very best thing that could happen here. Thank you for that.
Okay, are we done on all the business on the agenda? I think we are. Right. That ends the final hearing session, but as I said at the beginning, before I let people go home, I just want to discuss the issue of closing submissions. At the pre-inquiry meeting, it was agreed that those parties who took part in further procedure would have the opportunity to submit a closing submission, and in the notes of that meeting we suggested a period of 2 weeks, followed by the Council having 2 weeks to reply, but we said we would review that nearer the time. What we were suggesting is that anyone who was objecting, who elected to rely on expanding their objections by further written submission, or attended a hearing session, or as an independent witness to the inquiry sessions, should have until the 7th of January, if they wished, to make submissions. I have received an email. We have mentioned this informally over the inquiry session, and the case officer received an email from the non-home residents asking that period be extended to the 11th of January, and we were going to suggest the Council would have until the 28th of January to respond. Is that a reasonable timescale? Objectors to the 11th of January, the Council remains the 28th.
No, provided that timing is adhered to, so there's no issue with that from this side.
There is a procedural point I do want to raise about closing submissions. I understand that is a procedure that may well be used in planning, in normal planning inquiries, etc. However, this is a flood protection inquiry. It's the first one in Scotland. From our point of view, we're not happy with that. Now, let me explain. I mean, what we have to do is produce a closing submission by the 11th of January. Effectively, then, the Council is given some 17 days or so to respond to that. In other words, they get the chance to dismiss all of our arguments using all their engineers, lawyers, professionals, whatever, and they get 17 days in which to do it. And then we get no right of reply back as to what we think that is fundamentally unfair. Basically, I'm sorry, I can see I'm trying your patience here, but can you not see that from our point of view? From the very start of this whole inquiry, we have said there's an inequality of arms and a fairness and an unfairness and bias on the side over. We have to produce statements that they have 2 to 3 weeks to dismiss. What is fair about that?
The convention is that the promoting party has the final say. That's the convention, and we discussed this at the pre-inquiry meeting. And as far as I'm concerned, that was agreed. You don't have to submit closing submissions. I'm not going to send the boys round if you don't put in closing submissions. People in your position have found it helpful to pull it all together. And that's the procedure that we're going to stick to, I'm afraid. No, that's the ruling.
You're silent, so you're not going to let me comment on that.
No, I'm not. That's the procedure, and it's up to Save Our Sands whether you want to make closing submissions. But it's the convention that the council would have the final say, and I'm afraid that's that. Okay. We will get the case officer to write to the parties, letting them know that the case, and that will come out early next week. So, on that basis, I shall bring proceedings to an end. We would like to thank all the parties that have taken part in the inquiry process for their help and cooperation. We've carried out an enormous amount of work. We've managed to keep ahead of the timetable, and that's only been possible because everyone has been so helpful. I can assure you that is not always the case doing the job that we do. After we have received the closing submissions, that will conclude the process. And that's when we really start to earn our pay and write the report. It's obviously going to be a lengthy report. It's going to take us at least a couple of months, I would suggest, possibly more. When we submit our report to ministers, our website will tell you that. So if you've registered with the website for an alert, you'll find out when the report has been submitted. I have no idea how long ministers will take to consider our report and issue a decision. In my experience, it's usually months rather than weeks. And I've never yet found a situation where people are unaware when the decision is informed. I'm quietly confident that people will know very quickly once the decision is issued. And so on that basis, I thank everyone and hope everyone has a safe journey home. Thank you.
Just before we switch off the microphones, can I, and perhaps on this occasion speaking for everybody, thank both of you for your courtesy and patience throughout this prolonged process. Thank you very much.
Can I echo that, and particularly for your patience?